If I can have y'all's attention, it's about 2 minutes till 8:30, but if we start 2 minutes early, then maybe next time we late, that'll even out. Rick, would you mind saying a prayer for us? And also, we all need to remember Cammie Holmes. Well, she's not a Holmes now, but and how good she's doing.
Cammie Holmes, thank you, Mr. Chairman, because I want to thank you for the flowers to the committee. That makes so much to all of us. She has good days and bad days, but she is at least out of the hospital for 2.5 months. And I want to thank you all for your prayers. Please keep praying. She's got a long puff road ahead of her.
Well, she got a pretty good mom and daddy to look after her. So we think. Does anybody else have anything we need to worry about? Would ask the good Lord to help us with, other than what we doing up here. Rick?
Just bow our heads, please.
Rick, to all y'all that may be new to coming to ag meetings, we're not as strict as to how we do things like judiciary may be, but we do like to keep things running on pretty good. I would like to introduce our legislative counsel, Mr. Jeremy Avery, Jeremy Wave. He's the one that, if y'all got any lawyer questions, you need to talk to him. And Tracy Atchison is our committee aide. She gets me synopsis of bill before I even know we have a bill in ag committee. So thank you, Tracy. And she puts it in non-lawyer language so I can understand it. We have a new intern this year. His name's Taylor Origin. He's going, raise your hand, Taylor. He attended Georgia College and State University. We told him that he was the luckiest intern in the Capitol because he is in our office and he is trained by the best, which is our administrative assistant, and y'all all know she is the best one around. And we also told him that y'all know Mr. Abbott Massey's been around here since this place was built, and we told Taylor it was like playing. When you were with Mr. Abbott, it's like playing baseball in Yankee Stadium with Babe Ruth. So, you know, he's learned a lot from Mr. Abbott and everybody that hangs around in the office. So, on front of you, you'll find this little folder, this Ag Snapshots. It's kind of a real brief synopsis of agriculture in the state of Georgia for last year. This is what they give out at the Ag Forecast meetings. The university puts it out, and it's a real good little resource if you get questions on what's going on with agriculture. One thing on the agenda, have they got agendas?
No, we just do.
Okay. We were going to do the Seed Development Commission appointment, but I think we're going to hold off on that till next meeting. This is our first meeting. We were going to have one last Wednesday, but you know the governor made it snow and locked the whole state down, so we had to call it off, but maybe he won't do that anymore. So without any other further, does anybody on the committee have anything that they need to express any concern over before we get started? All right, Senate Bill 213, Mr. Buddy.
Thank you, Mr. Chairman, and am I on now? Yeah, okay, just make sure everybody can hear. Listen, I appreciate the opportunity to come before you with this bill, and as the members of this committee know, we did pass this bill out last year, but did not have time to get it through the process. In regard to that, I want to thank the members of this committee that have helped me basically correct some things that they felt was not proper before, and get the bill, in, I think, into really good shape. Some other folks I'd like to mention is my friend Gordon Rogers, who's with the Flint River Keepers, invited me to go down, paddle down the Flint with them, and I picked up a lot of information from Gordon that helped us to refine the bill, I think, to where hopefully everyone will be satisfied. Also, I want to thank Farm Bureau, who is supportive of this bill, Georgia Agribusiness Council, the Georgia Chamber of Commerce, and Georgia EPD, who have worked very hard to help us refine the bill to something that is what we really need. In working on this bill, I've looked at water conservation as a worldwide problem. It's not just a problem in Georgia or South Carolina and Alabama that we've been fighting with over some water wars. It's a worldwide problem, and I think that this committee is doing a good job with this bill and seeing that we are part of the solution, particularly in a part of the area that is very economically beneficial to our state. The governor just spoke to the people of the Agribusiness Council, and I believe he said $77 billion industry now, which is up about 10% from the last figures I heard. And as I'd give you a few facts about this particular bill in this particular part of the Flint River, I think you'll see how important it is. Now, as far as water conservation is concerned, different areas of our state have different problems. As we know, Savannah has a saltwater intrusion if their aquifer level gets too low, the same aquifer as we have in the area we're talking about here. We've seen some pollution that is caused fish killed in some areas, some rivers in our state. And we have spent millions of dollars in legal fees with the Chattahoochee and the Lake Lanier with the Atlanta area. So every section of the state has a different problem, basically. And what we're talking about here today is so important to the biggest industry in our state that I want to thank the committee members in advance for listening to it and for letting me ramble just a little bit. Mr. Chairman, you can cut me off if I get too long-winded here. But this particular bill is to put maybe tools in place and regulations in place that will allow the state to react if we have a severe drought. Because this area of the state, now to give you an idea, back in 1954, and I actually can remember that far back, although I read this in a report, this state had less than 30,000 acres of irrigated land. Right now, we have 1.6 million acres of irrigated land in the state of Georgia. 600,000 of those are in this area we're talking about. And they produce in this area about 38% of the row crops that are used for food in this particular area of the state. So I think it's very important that we come up with something that gives these people a reaction plan. And, you know, we can't always be prepared for everything. We had the perfect storm, as the chairman mentioned, here last week with the snow. But we at least need to be building blocks that will help us when that time comes. And this is only part of the state that's affected by this, is that part of the Flint River Basin, which is over the Florida Aquifer Basin. So, and that is south of the fall line down southwest Georgia to the Florida line. And that's where we have 600,000 acres of irrigated land. So we've got that's over a third of the irrigated land in the state, about 38%. Down that way, our farmers are very fortunate in having the Florida aquifer that they irrigate out of mostly. There are 4 aquifers. There's the Cretaceous aquifer, which is the deepest, then the Clayton, then the Claiborne, then the Floridan. The Floridan aquifer is used mostly because it is the closest to the surface and has greater efficiency as far as getting water to the crops that we so badly need. I've also done a little research on the ecology because of the concerns of the environmentalists about this bill. And I did find that in this area there used to be 29 species of freshwater mussels. They are down to 22. And what concerns me is as we move along and these populations, if they do continue to decrease, then we will may have some problems out of Washington as far as EPA on endangered species. So I think this bill will help us look at that and make sure that we stabilize the aquatic environment, so that there's a lot of fishing on that lake, on that river too. In fact, I live on it, and I know how important it is that we keep the water levels at a place that protects aquatic life and any species that might be endangered. Just as a sidelight, do any of you know what Yoni-odins are? Gordon probably does, but that is the freshwater mussel that is in this area, and that is the right pronunciation. Don't get me wrong, but anyway, just to let you know that I have looked at the ecology, at the environment, and at what this will do to protect our farmers and our food crops in the future. There's a lot more that I could say, but let me just go and instead of going through the bill line by line, let me try to point out some of the things that basically were modified a little bit so that we would meet the concerns that were expressed by the people I mentioned in the beginning. Yes. Yeah, I'm sorry. Yes, there are 2 copies in your, and we're working off of LC ag020514EDITED. And that's the one that contains the latest changes that were made. Now, first of all, I'd like for you to note on line 80 through 86 that this bill kicks in if there is a severe drought. Now, a couple of years ago, we came close. Fortunately, this last year we had plenty of water, all aquifers are charged, and everything's in good shape. But if there is a severe drought, then the director will declare that by March 1st, and that's when the provisions in here really kick in that are related to some of the provisions that are in here. Then if we go to the riparian rights were raised, and actually the state of Georgia operates on regulated riparian rights. We have a letter from a very well-recognized law firm that says this in no way changes the regulated riparian rights of the people we have. But with working with EPD, we did put some language in that we felt like would help somewhat. And there again, we had questions. I know that y'all have heard the talks here that there was a project in Spring Creek, which is a tributary of the Flint River, where there were some endangered species, and in that case they dug a well to augment the flow. And I had a concern from a member of the General Assembly that I respect highly that said, you know, we don't want people to use that flow after it's put in the river. Well, if it accomplishes its purpose, then why can't we let it be used? Sounded good to me, so we made some wording change that says once the purpose of that augmentation, if you will, like was done at Spring Creek, is accomplished, then that water is no longer restricted. And you'll find that in lines 175 to 182. And that says that, of course, the director is authorized to notify specified permittees with surface water withdrawal permits downstream of a state-funded project. In other words, if we've got a drought and we've got this project, then they will be notified. And they will be notified as far down as the project site goes, and then the water, again, is open. Another thing that will help protect those rights is that this bill originally contained, and still does, basically irrigation auction. and that is the state could pay for those who were deprived of the use of that water. However, when the bill was first written, we couldn't do it because of the number of irrigators, and if there was a drought, it would have broke the state. We'll put it that way. But this way, I have looked. There are just a handful of surface water irrigators below this region, and so it shouldn't. In fact, I talked to one this morning over the Agribusiness Council, and he understands that this, even if it did mean that he couldn't irrigate out of the Flint. Of course, he irrigates out of ponds first and the Flint last, but that there was a possibility that he could not be put in a position of substantial economic loss. So that has been done to ensure that the regulated riparian rights of all our people are protected. There is an administrative review section in here. If a person feels like their rights have been not adhered to, then they have an administrative review process. And I mentioned the irrigation auction, that's also another protection there. Another big part of this bill is irrigation efficiency. And quite frankly, that's the part that is incumbent on our farmers. And they basically have already just about met the needs of the standards of this bill. It requires certain irrigation efficiency by certain times. That's the reason this bill was sent to this Agricultural Committee instead of the Natural Resources Committee. And I think that was a good decision, because we want to be sure that these farmers have the ability to raise the crops that we so badly need. But that's, I don't know whether you have ridden in South Georgia very much down this way, but down there, used to, you go by and these irrigation guns were just wetting the highway, and as Chairman McCall and I were talking this morning, you get a good car wash if you went by. I have ridden this area a lot recently, and I think I have seen one irrigation system that still uses those big guns. Now, the rest of them, if you're ever riding around, you'll notice they use downspouts to put the water right on the crops to prevent evaporation. And in addition, they have technology that will tell them when the amount of water needed for that crop at that time has been applied. And those of you who went with us to the expo understand that. So I think this bill has put together all of the things that we need to ensure that our farming is protected, the biggest industry in the state, that the farmers' riparian rights are protected, that the environment is protected, and I would just ask your favorable consideration of Senate Bill 213.
Thank you, Mr. Buddy. What we're going to do, this bill has been around since the first of last session. All summer long, there was meetings all over southwest Georgia on it. Buddy even floated the river with Gordon. Did he wear a bikini or what, Gordon, when he was floating? That's what. But anyway, what I want to do is we have a sign-up sheet here with 4 or 5 people on it. I want to let them talk, and there were a couple of organizations that had pity on us and didn't want us to have to listen to them talk, and there's a letter on your desk, in front of you, stating their position on it. But we talked about it. Last time we had this in committee, it was like a federal court trial. We're going to give each member one question, so make it a good one, to whoever you want to ask it to. So I'm going to let the people that have signed up to talk go on and talk and express their concerns, and then if any members of the committee have a question, decide who you want to ask it to, and then we'll go from there. And the reason I'm doing this is we got people that have to be on appropriations, which takes precedence over most anything going on right now. Rules meeting kicks in at 9:30. We got members on the Rules Committee, and I don't want to lose a quorum. So I'm going to start with Jason Rooks. We're gonna try to hold it to a couple of minutes, if that's okay.
Good morning, committee.
How you do it?
Am I on? I'm here today, Jason Rooks, representing the Georgia Conservancy. And some of you guys know we've been down here doing water for a long time as a lobbyist with this committee. And I'm here to express the Conservancy's opposition to this current draft of the bill. You know, I am a lawyer. I didn't sleep at a Holiday Inn Express last night, but I'm having a difficult time understanding the language in the draft that I just received yesterday afternoon. I think we're talking about some very serious legal implications of 200 years of Georgia water law. There's some folks behind me who can speak to that more directly, and I just, wanted to express our opposition and also my thought of a Senate bill. We're not at day 30. This bill's crossed over, and I know it's a very important piece of legislation. I just hope this committee and the chairman will take the time that this bill deserves so we all understand exactly what's in it and the implications to the bill.
Thank you, Jason. Todd Holbrook.
Thank you. I'm representing the Georgia Wildlife Federation. 213 sort of can be called and is referred to as Flint River Drought Protection Act, but it in fact is statewide in nature. And I think I'd like to begin my comments with concerns on endangered species. That type of augmentation is going on right now. It's happening in Spring Creek as referenced, and it's happening over on the coast of Harris Neck. So it doesn't necessarily require, in order to meet endangered species, it's not required in order to meet endangered species needs. From the Georgia Wildlife Federation standpoint, stream flow, whether it's augmented or otherwise, needs to be more than the minimum necessary to keep us out of port, keep the state of Georgia out of port. Species that we are interested in, species like shoal bass, migratory species, travel at least 100 miles up and down the Flint River and travel in other river systems as well. And the people who like to catch them need more flow than that. That's not where we need to be thinking. I believe there's a problem with the undefined nature of augmentation. For example, you might be able to argue that Lake Lanier augments the Chattahoochee River. How much of that flow is then somehow protected at some distance? So I think really the solution lies in a little more work on this topic. We need a statewide stream flow policy, and let that work toward getting a definition of what in fact is augmented water and what isn't.
Thank you, Todd. Hang around for if somebody may want to ask you something. In a minute. Let me get through to Gil.
Thank you, Mr. Chairman. Good morning, everybody. My name is Gil Rogers. I'm with the Southern Environmental Law Center, and I really appreciate the opportunity to appear in front of this committee. I also appreciate the extra time that's been taken to work on this bill. This is a very important matter to keep healthy flows in the Flint River. Unfortunately, we've still got a lot of concerns with this whole idea of flow augmentation as it's expressed in this bill, specifically the section lines 172 to 203. That's what's been referenced in the comments that you just heard from Todd Holbrook and Jason Rooks. The issue of keeping enough flow in the Flint River to protect endangered species is already something that Georgia law and federal law provide great coverage for. The director of EPD is authorized by statute now to adjust flows, to respond to emergencies, and to make sure that there is enough water to keep the system going and to accommodate all the farm uses in particular that are in southwest Georgia. In addition, federal law, specifically the Endangered Species Act and the Clean Water Act, provide coverage particularly for protection of species with enough flow. So changing law in this way that's proposed is not necessary to accomplish that goal. And our additional concern is these changes open up cans of worms that are not currently open. As Todd said, the definition of augmentation is not present in this bill. It is not clear that the state would even have to manage or own an augmentation project, so you could have a private entity actually doing the project. The nature, the duration of the augmentation project is not well defined here. And again, if you've got a stream with water flowing through it, it's almost impossible to know what is the augmented flow and what is the non-augmented flow. So from just an implementation perspective, this is just very unclear how this would work. It's also not clear that the director has to follow any set criteria in terms of designating those people who get to keep their water withdrawals and those who lose their water withdrawal rights according to this section. And that's where we start getting into real concerns about our basic riparian rights system in Georgia, which recognizes water as a public resource. Everyone gets equitable, reasonable use of the resource, subject to some oversight to keep the system healthy. When you start designating people who get to use water and people who don't, with no real equitable overlay over that, that starts interfering with riparian rights. And the other problem is, as Representative Hardin alluded to, a lot of the problems in the lower Flint are caused by groundwater overuse and not surface water overuse. There's no provision in this section that deals with that groundwater overuse problem. So even if you have an augmentation project, you start to run into concerns that the groundwater use will defeat the purpose of the project, even if the surface water withdrawal permits get cut off. So there's still a lot of problems with this particular section. We certainly support other aspects of the bill. And I would submit that this section is not necessary to do what's already being done in Georgia in terms of flow augmentation. And for that reason, we continue to oppose the bill and have concerns about it. But I'll be happy to answer questions. And again, appreciate y'all's time this morning.
Thank you, Gil. Mr. Gordon? I'll give you an extra minute if you'll talk about Buddy and the paddling the boat.
Well, you can count on that. Thank you, Mr. Chairman and ladies and gentlemen of the committee. Mr. Buddy is correct that we did paddle together. In fact, we got fairly close several times. We were talking so much that we ran into each other a couple of times.
On purpose?
No, we were real animated.
Okay.
We were very engaged. However, unfortunately, Representative Hardin didn't share any of these changes with me this summer, or this autumn, or this winter. I got to read it yesterday.
That's about when some of them happened.
And we did offer changes to Director Turner on two separate occasions, once on day 40 and once back in October, that would have fixed the problems that we have. So with that introduction, I'll tell y'all that I'm the river keeper for the Flint. We have just under 700 families, farms, and businesses that are members, a little over 3,000 folks that stretch from the upper Flint, Fayette County, Cada County, all the way down to Lake Seminole. And there are folks that make their living off of this water as well as enjoy it for drinking and cooking and bathing in and fishing in, swimming in, having baptisms in. Use it for everything. This bill creates winners and losers. The plain language of the bill does that. It's complicated, but it's also plain. In fact, the changes that everybody got to see yesterday actually focus that a little bit more, because it now says that the director shall establish lists of permittees that are in and out of this program. So you have clear winners and losers in the ag community. You also have clear winners and losers because it doesn't address any of the issues in the upper Flint. and the relationship of the Flint to the Chattahoochee's flows. And so there are folks whose problems are not addressed in this Flint River Drought Protection Act. I have a letter here to Director Turner that's signed by quite a number of farmers, some of which names you'll recognize if you're from farming communities, including the largest peanut producer in Georgia is at the top of the list, who have a problem with the bill. And one of the problems they have, one of the fundamental problems, is that it only addresses ag. It doesn't address the rest of the Flint. And then there are some issues about equitability. The language that we gave Director Turner would have regulated all users, groundwater and surface water, equitably when there was a flow problem, rather than establishing lists. The losers are the farmers. Don't be fooled. And the losers are also people that need flow in the river for other reasons or desire it. The winners in this case are folks that are embedded in the bureaucracy that are in league with insiders for investment projects to make money off of the pain of others. That's who the winners are. We don't know who those investors are yet, but this bill establishes a new property right that would be administered by the state of Georgia in league with investors, and those would be the winners. Now that could be winners in Metro, that could be winners somewhere else in some other state that make money off of this, but it definitely creates winners. Again, our compromise language would have regulated everybody, not just a handful of folks, which is the way the water law in Georgia is now. We don't need this change. When we delivered the language to Director Turner, he gave us the message that his coalition could not live with it. And it's interesting that the director has a coalition versus just managing the water for everybody in the state. The bill is anti-ag, it's anti-Flint, it's anti-property rights, and it's pro-insider. And it's being dressed up as an ag bill, but that's not what it is. Those are my comments. I do wish that paddling had resulted in something that I could live with, but we can live with paddling again, and
we can disagree and be agreeable.
We can disagree on the water or in this room and be agreeable. And I look forward to a better bill for the Flint some years down the road. We oppose this bill and urge a no vote this morning. Thank you.
Thank you, Gordon.
We will invite the whole committee next time. Yes, ma'am. Okay. Thank you, Mr. Chairman.
Appreciate you coming up here. Director Turner.
Thank you, Mr. Chairman, members of the committee, and Representative Hardin. I really do appreciate your hard work on this bill and your introduction of it today. I thought you did a good job to sort of describe what we've been trying to do with what I've been talking about as a little sweet tea diplomacy all summer, as we've talked to a lot of folks. And look, I appreciate the pro and con stakeholders, the folks that are still against the bill. I appreciate their input. I will tell you, until my friend Gordon got up, I thought we had a change in tone and tenor that was nice in this sense, and that was that we were talking about unintended consequences about the bill, which I think this what a committee process is all about, what a legislative process is all about. I can tell you, if I was a master of that sort of intended consequence that my friend Gordon's worried about, I would be the most powerful master of whatever that may be going on here, but it's not the case. Let me just tell you, because I think the bill's been explained, let me help you sit in my chair just for a minute. When I got this job 2 years ago, I looked at stream flows in the basin, and these aren't in the Flint stem directly. They're in these feeder creeks like Itchaway, Notchaway, and Spring Creek, and Little Pachitla, and some of these places where we do have some of these populations that we're worried about. And I'm sitting there looking at it, and the only action I could do that I felt like I could do immediately was to suspend new permits in that lower Flint. So I did that as an action of the director. But I'm looking at flows that were scary, and they're scary because they have ecological impacts, but they're also scary on the agricultural side of the house, because if we do have enough impacts and we end up before a federal judge over this issue, we might have a more draconian approach to how to manage this situation. I've also been living with being involved in the litigation related to Florida and Alabama, and I know that we've got to do some things to manage ourselves in this basin, and I needed some help. Now, this bill is not the end-all be-all, and right now my commitment to everybody in this room is that there's going to have to be some more about how we look at the Flint River Protection Bill, but we got some studies we need to do. We need to understand these lower aquifers that Buddy mentioned and what kind of sustainable yield they have. And if I were coming back to you with all that has been offered, which is a system in which we would set an in-stream flow level for ecological purposes and then limit everybody's permit to meet those in-stream flows when there's a drought, surface water guys and groundwater guys, you would hang me out because I wouldn't have the data to show you how we were going to do it. But we're working on figuring that out, and my commitment is that we're going to do it openly. We're going to do it. Gordon, you're invited. Everybody's invited to be part of that process. And what this was a realization that we needed to take a couple of steps. And so there was this ag efficiency piece, which frankly took a lot of work with our farmers and farming community, and I appreciate the willingness and the openness to be pushed along. Most of them are there, some of them aren't, and we need to bring those guys along. And these were recommendations out of the Lower Flint Council. These were not stuff we ginned up on our own. And then the second, and this is the one I want to talk just a minute about, related to this augmentation piece. It is true that we are doing a modest augmentation project in Spring Creek. Guess what? There's no surface water withdrawal in Spring Creek. So, yeah, I can do that with it. There's no authorization. What we're doing on augmentation doesn't authorize augmentation. It doesn't in this version, and it didn't in the previous version. What we did in this bill was articulate that you're going to have a right to hearing, of course, but the action is normally when you appeal an adverse action of the director, it stays the action of the director. Well, that's going to be hard to manage in the middle of a drought when we're trying to actually do this. And I was looking at a situation where we might have had to do 10. Let's just imagine a world in where the drought lasted another year. We were going to need to do multiple of the Spring Creek projects around the basin. And there were likely to be a surface water permittee or two that was going to be impacted. Now, from a legal standpoint, we're going to have to work out the details. This committee will see that in a board rule before the Natural Resources Board. And the bill really lays out what that rule needs to include and provides that the distance for the projected, what Buddy talked about, is going to have to be in that rulemaking. And that's the kind of technical work that's going to be open to public comment and before the board. And so those kinds of things are going to have to be worked out. But don't trust me on this. Just think about this practically. There is no way, irrespective of what everybody says is going on here, there's no way in which the state augments at 5 or 6 CFS to protect in one of these feeder streams that are about to go dry. There's no way we're trying to trace that 5 CFS to Lake Seminole and keep somebody's. I'm a lawyer too, and I don't want any part of that. I don't want any part of 15 miles downstream where 2 other tributaries run together, and a thunder bumper happened yesterday afternoon in a separate basin, and I'm arguing, no, you can't touch 5 CFS of the 10 CFS that's in the river. No. We're going to have a certain area we're worried about, and we're going to be notifying those folks in that area. So put your practical hat on for a second with me, and this is why we did this. This is why we asked for this. This is why we worked on it so hard. It is only the beginning. This committee is going to be involved. I think this is about managing our own house instead of having it managed by the federal courts. It pushes us along in the agricultural community, and I appreciate the folks that recognize that's good for the industry. and for this committee. So there's a lot of good work here, and I appreciate this committee's attention. And with that, Mr. Chairman, I'll let you have it back.
Good, all right. We're going to do one question apiece to whoever you want to ask it to. So we can start right here with Robert if you got one.
I'm good.
Rick?
I'm fine, Mr. Chairman.
I know Miss Regina does to somebody.
Can I get a phone a friend to ask her other questions?
You got a good many answered last time.
Yes, sir. I have a question for Director.
Yes, ma'am.
Director Turner, I'm going to try to get all these thoughts into one question since I'm being rationed here myself a little bit this morning, and I appreciate our time constraints. But given what we know about surface water law in Georgia, and that is that a democratically controlled General Assembly took rights from the citizens along the Flint River as to surface water in 1972 and as to groundwater in 1977, and that in a regulated riparian and regulated reasonable use system which now exists along the Flint River, it is the scope of the regulations that determines the rights. So is it not true that Senate Bill 213 now asks a Republican-controlled General Assembly to extend government by adding regulations, which by definition takes away rights, but now also flexes the power of government, which does not now exist, and allocates water and affects private property rights along the tributaries, which were not previously covered? I think I could. I wrote it down.
No, ma'am. My view is not that there's an expansion here, but a clarification of the regulated riparian system we have. In an emergency, the director's office would be authorized to do this. What I know is a practical reality, and you, ladies and gentlemen, that particularly know some of our good friends in Southwest Georgia and other places that farm. While many of them are very sophisticated and would understand what we're trying to do, there's a very good chance some would disagree with me and would say, look, that water's in the river and I'm going to take it out, even though the state's putting it in 100 feet from me or 200 feet from me for a very specific purpose. So really, all that's in here is a clarification of that so that we're not litigating that when we try to get to it. And we would have, or we will, in that scenario. This clarification will help us avoid that.
I don't have any more questions because I can't have any more questions.
Thank you, Mr. Chairman. Either Director Turner or Buddy could probably answer this. Of course, we know how important water is in the ag community. I remember my first class in college, Animal Science 106, Dr. Buck's first day said, every glass of water we drink's been drunk 6 times before. So there's no more water to come around, and that's what we got. So I do think, I am concerned that there's some overreach of government. I've expressed my concern before about I don't think it's government's role to tell agriculture what irrigation systems it should use. But I've been focused on defining the severe drought and what kicks this all in. And we've added some language. But in discussions yesterday, and we can thank Brian Toller for this, when does it end? You kick it in on March 1st. You say we're expecting a severe drought. What shuts it down? What says we're no longer in that condition? There's no language that, we could say something like if the Palmer Index rises above a -2 for 3 consecutive months, it would be over and they go back to normal. But there's nothing in this language. We let him kick it off, but nothing stops it. It would be, how would we end it without language?
Well, the way we ended it before, which would be relevant to this because that's what the existing law says. I mean, as a practical matter, this is an annual consideration, right? I mean, one of the problems was that we need to make sure we communicate early enough because folks obligate their land and rent it out and make decisions based on what they're going, crop selection, all those things earlier than when they actually put it in the ground. So, but it's an annual thing. So I think we've got to, by each year, you've got to make that determination. So it's not like it stays in for the next year automatically. It's my understanding we're going to make that annual determination. If it doesn't say that, it hadn't said that before. If it doesn't say it, and that's how we did it before.
Well, and also the word here is putting in, but if the division predicts severe drought during any particular year, it shall issue such prediction before March 1st. So you would have to the next year at least. It could not last longer than a year without any prediction.
That's my grandpa, goat farmer.
Could I defer to the chair? I have the same concerns I've had all along. I think I've shared them numerous occasions. I need to take my beautiful Farm Bureau scarf off when I vote. I will. I don't have a specific question right now, so
I just have one question, and Gordon, I appreciate you came to visit me this year, and I had seen the same letter that you brought. Have any of the farmers withdrawn their support? I have been contacted by numerous farmers. This is my district. So I've had some farmers come to me, in fact, most of them, and they want this bill. That's why I've got a little conflict here.
I asked the author of the letter yesterday. His name's Robin Singletary in Mitchell County. If he was aware of any farmers withdrawing their support, and he said he was not. He had been on the phone yesterday morning with a whole bunch of them trying to get somebody to drive up here on fairly short notice to testify. So he was actually in contact with a bunch of them yesterday. I don't think he called the entire list. But he's not aware of any that have withdrawn their support. I'm not. There may be some. I don't know.
That's my issue, because some of them are my farmers, and they have, and their name is still on the list. So.
Okay.
Thank you, but I appreciate it.
They probably need to let Mr. Singletary know that.
Thank you.
Thank you.
Is that the June last year letter?
June, yes, it's in June.
And I'm fine with this, but I do want to say that I appreciate very much all the time and effort you spent on these good bills. I just appreciate everyone that presented here this morning. And I do have a question for Director Turner, like this. Mr. Gordon mentioned that you feel this bill is not being regulated for everybody. Can you address that?
Sure.
Let me understand why. I know you can't speak for Mr. Gordon, but.
Well, what I took to being his point is that one way of saying this in the more positive fashion is this is a very targeted bill. It is. It's, if we're going to augment for this very specific set of circumstances, again, I don't maintain that this is the fix-all bill. It is just a small but important step towards us managing our house down there. And so, yes, if the state gets in here and does some augmentation, it is going to practically target protecting that flow just to the distance it's needed for the purpose upon which the state taxpayer dollar is being expended to put that water in the creek. And so, yes, that means we are not we're not doing a reach into the groundwater users that are not on the river and getting into that argument in this first step. We're doing what we know would be a direct impact. I mean, if you put a CFS in the creek and you take a CFS out of the creek with the surface water withdrawal, that impacts 1-to-1, and we could defeat the whole purpose of doing it. So it's very practical. This whole thing's just driven at some practical initial steps to manage the basin.
I didn't see Sam's cutting that down. He's back in the middle.
Yes, Mr. Chairman, appreciate it. I just want to make a comment. I'm a farmer in Southwest Georgia. I just want to thank the departments for bringing this legislation forward. I think it's crucial for us to have as a tool in our toolbox when the federal courts come down and try to regulate us as farmers. I think it's something that can help defend ourselves against them, and I think it's great legislation. Respect the y'all put in place.
Judge, can you just explain, one of the questions of this is the fact that we hear, on both sides of this, that we already have legislation in place that will allow us to augment the stream flow, keep the animals alive or whatever. Why do we,
Right, sure, great question.
Why do we need this?
it's really a practical legal reason, and that is normally without this legislation, we would do the augmentation. Let's say it didn't rain and I had to do this 5 other places, and I did this, and all of a sudden we did it by checking with our Wildlife Resources Division and some of our folks in Fish and Wildlife, figuring out where certain populations needed to be augmented. Let's say we went in there and did that, and let's say there's a surface water withdrawal right there, and it's a drought. His intake's sucking mud at the moment, and we put 5 CFS in there, and he's tempted to take it, and I tell him not to, and he says, well, force me. I could then notify him that he should stop taking that water. He can then, that's an action of the director. He can then appeal that, and by our rules it would stay the action during the growing season, and he continues to take it. So all we were trying to do is say, look, in this case, the stay's not going to operate. You still have an emergency appeal to the ALJ. You still go that route. The action of the director is not going to be stayed, because in a typical case like that, we'd stay the action and we'd defeat the whole purpose, because it's only a growing season issue anyway. And you know how the court systems work and how long it takes to get through that. So even on the administrative side. So that's really, we're talking about authorizing augmentation. No, I mean, one of the things there's these other issues related to ASR and some other things. Those are going to happen with or without the bill. This part about the stay provision and the technical piece on the hearing is the reason that this is needed.
Real quick statement. Yes, sir. I just want to say, even though we know the best and the brightest are on the Ag Committee, there are some times, and this is one of those bills, that we need the input of the state. This affects everybody in the state, and I think this is one of those bills that needs to move on just so everybody on that House floor can discuss it. And I would hopefully ask you to encourage the Rules Committee to let this hit the floor as open as possible so we can have a lot of debate, and if something needs to be changed, let all 180 members look at it and be able to talk about it and make sure we have something that work for all of Georgia.
Am I reading that as a motion?
Yeah, you can call it a motion, yes, sir. Do pass.
I second that. All in favor say aye. Aye. Opposed, no.
No.
Let's do the hand. 1, 2, 3. Yes or no? Oh, I thought you raised your hand. 3 to have one in the rest together. All right, thank y'all very much for your input next time. We got one more bill committee we got a second. I promise Chairman Wilson. Y'all are getting a copy of the bill. Ain't got a thing to do with agriculture, but it's consumer affairs. So, anyway, go ahead, Chairman Wilkinson.
Okay. Thank you, Mr. Chairman. This does have to do with consumer affairs. This is a bill, Senate Bill 209, that this committee passed unanimously last year, and it passed the Senate last year 49-1. Later on, there were some concerns about how broad the bill was, so with this substitute, it's just narrowed the focus some. It does 2 things. It creates permissive language in the Georgia Code for businesses providing these self-help services so they avoid costs associated with frivolous lawsuits for providing these materials to consumers interested in performing transactions themselves, and it ensures consumer protections by notifying the consumer that forms and templates are not a substitute for professional advice and counsel. So this would clarify that a consumer does have the right to use these self-help documents. And Mr. Chairman, members of the committee, I appreciate the opportunity to be with you. And I talked to Director Turner. I told him since he was warmed up, I was going to let him answer the questions. But if you got any, I'll attempt to answer them. right now, for instance, if you want to do a will, you have the opportunity to go online and you can do the will yourself. What this would do, it wouldn't make anything legal that you can't already do, but in some states there have been lawsuits that contested your right to do that. So this would just clarify that you have that right. And it would also, they would have to let you know that that it did not take the place, it was not a substitute for legal advice.
I looked up, and I'm sure Regina knows these code sections better than I do, but I had to look them up this morning to see what they were. 15, 1950 to 58 is all about what you can and can't do as a lawyer in the state of Georgia, right? And it's every one of those code sections, and I got it written down as to what they do. Huh?
We need more cans.
Yeah. Well, what this is if you go online and fill out a form, whether it's a will or a living will or whatever, all it says is whatever website you go to has to clearly and conspicuously state that they are not a substitute for the advice of an attorney. That's pretty much it, right, John?
Mm-hmm. And Mr. Chairman, I think just even as a lawyer, I mean, this certainly is something that is pro-consumer in terms of its scope, and it's probably more important because there's a piece of legislation that will be moving through about adding some civil penalties under Georgia law and actions for damages about the unauthorized practice of law for people who are actually harmed by people not giving these disclosures and pretending to be lawyers. So I certainly support the bill, Senator.
Thank you.
Does anybody got any more questions? Anybody got a motion? Do you do move to pass it a second? All in favor say aye. Thank y'all.
Thank you very much.
Who did the first motion?